Now, even though the court did not consider the constitutionality of 922G as a whole, they did unanimously agree that Mr. Khamenei's conviction was a violation of his rights protected by that document. Held. The government's prosecution of Mr. Khamenei under 922G3's unlawful user provision is inconsistent with the Second Amendment. However, the court was very narrow in its decision. The court's decision is narrow. It does not address efforts to ban addicts or those presently intoxicated from possessing a firearm. Other prophylactic laws Congress may adopt after determining that users of a particular drug pose a special risk of misusing firearms, 922G1's provision disarming individuals convicted of felonies, or whether the government could bring a prosecution under 922G3 accompanied by individualized proof that the defendant's drug use render him a danger to himself or others, or proof that a certain drug always renders its users dangerous. That last provision, that government can bring a prosecution under 922G3 if they also bring proof that the defendant's drug use makes him a danger to himself or others, points out the fatal flaw in the law, because nothing in the law requires such proof, only proof of the use of a drug that Congress does not have the legal authority to regulate. I think the court came to the correct conclusion. I only wish they had taken Justice Thomas's and Alito's words to heart. The Commerce Clause does not grant to Congress the legal authority to regulate anything that may have once passed through interstate commerce, and Congress's drug schedules do not prove someone using them is violent or dangerous. Just from what the court showed in this decision, I believe 922G is unconstitutional and therefore illegal and void. I guess we'll have to wait for another case for someone to actually do something about it.